A very good morning. I am Dr. Avnish Bhatt. I warmly welcome all the guests, not from every corner of the India, but from more than 10 countries. People has joined in this August occasion, and it's a miracle and a dream come true for all the legal fraternity throughout Asia, throughout the every parts of the world, that we are gathered here, assembled here to listen Professor Dr. Upen Bakshi. And I humbly request now to Professor Dr. Yugal Kishore, Dean, ICFI Law School, the ICFI University, for the opening address. Respected sir, over to you.
Thank you. Thank you, Avnish, Dr. Avnish ji. Most respected, distinguished, eminent keynote speaker of the day, Professor Dr. Upen Bakshi sir, my esteemed Professor Hargopal Reddy sahab, VC of ICFI Law University, Professor Dr. Buddhu Vinay ji, Registrar, Brigadier Rajesh Sethi ji, Academic Coordinator, Mrs. Manika Kharola ji, distinguished academicians, law professionals, students, ladies and gentlemen from India and abroad. Today, ICFI Law School, ICFI University, Dehradun is organizing international webinar on future of basic structure, doctrine, and essential features doctrine. So on this occasion, I, Professor Yugal Kishore, Dean in charge of ICFI Law School, wholeheartedly welcome one and all present here. Now, I will be speaking about a little bit on the university. So ICFI University was established by a great institution builder and educationist, Mr. N.J. Yashasvi, through an act of legislature of Uttarakhand in the year 2003. From its inception, university has maintained high standard and decorum, with the result that this year, ICFI University, Dehradun has secured 44th rank in the World University with Real Impact, which is called as URI, released by United Nations Institute of Training and Research. ICFI Law School, in the same way, has secured the 6th rank at Law School of Super Excellence at India level and first at the Uttarakhand level by CSR CGHRDC rank 20. ICFI Law School has also been ranked 26th among top law universities of including LLUs by Mudra MUMDRA ranking 2000 conducted by India Today. In fact, with regards to our topic, which I've already spoken, the preamble of our Constitution of India is the heart and soul of the Constitution. All features of the Constitution are enshrined in this. Indian Constitution has been amended a number of times. A Constitution which is changing, and rather I'll call it in another way, a Constitution which is unchanging and static. It does not matter how good it is, how perfect it is. It is a Constitution that has passed its use and time. So actually, it is gradually approaching towards its death. A Constitution is to be living, must be growing, must be adaptable, must be flexible, must be changeable as the society changes, as the condition changes, as the world changes. So we are very fortunate to have with us today a very distinguished, eloquent, eminent, dynamic academician and jurist of all times, Professor Dr. Upen Bakshi sahab, to speak on this the topic of future of basic structural doctrine and essential feature doctrine. Now, I request the Madam Ekta Galawat to please provide a brief introduction of our Professor Dr. Upen Bakshi sahab. Thank you. भूल गया यहाँ पे लिखा रहता है।
Okay, respected sir.
Shall
Okay.
we start? Ekta has to unmute.
Okay, sir, without wasting a minute, I will proceed. Okay, so for the brief introduction, I think it takes a
Very big.
numerous years we have to take to introduce our honorable sir and our whole legal fraternity, well versed about, admire, adhere to all the work sir has done in the legal field. But to give a few glimpses of sir as former vice chancellor of Delhi University, South Gujarat University. Sir was the former Director Research of ILI. Sir was the former President of Indian Society of International Law. Few of Sir's engagements are from the American University, University of Sydney, Duke University, New York University, University of Toronto, and many other established and well-versed universities. Sir has written several numerous articles, books, thought processes, which we all admire and adhere to. Now, without wasting a minute, I quickly and I humbly request our honorable guest, sir, please entitle and enlighten the gathering with your intellectual and juristic thoughts. Over to you, sir.
Thank you very much, and welcome to you all to this great occasion. Mr. Vice Chancellor, the Dean, the Registrar, distinguished colleagues and friends, and all the numerous participants in this webinar, and dear students. It's really a great achievement for the university. For me to hear particularly how great it is and how many laurels it has won, particularly law school. And I wish you the very best ahead in the future. Since I'm speaking about future, I was referred to by the learned Dean as a distinguished person. Well, I divide humankind into two species or subspecies. One is those who are distinguishable and those who are distinguished. And I classify myself in the first category, not the second. With that clarification, I'm so glad that the university's basic structure is sound and will adapt to the growing needs of the future. I am privileged indeed for this occasion, but I want a discussion, a dialogue between you and us, all of us, and therefore I will concentrate on half a dozen brief points, and then perhaps to arrangement for questions and answers and discussion. So let me begin by saying, and that is point number one, that it is not easy to read the future of anything, individual, institution, ideas, events. It's impossible perhaps to read the future. It's like reading the tea leaves, as it were. So, but in some senses, one may say the future is always present. We live in the present, and the seeds of future lie in present. Giorgio Agamben, an Italian philosopher and a good friend, wrote recently in a book, a short book. He specializes in writing short books. His largest book is 150 pages. And he's been promising me a book of 400 pages, which is not yet written. But Agamben said once recently, and he wrote a small book of 50, 60 pages on this very subject, on how to read a book that is not written. How to read a book that is not written is the riddle of the future. You know, or my great author, Rashid Taleb, I think, speaks about future as a known unknown. In other words, there is something about future that we already know, but we do not know fully. And therefore, the potentiality is the most important aspect of future. The potential to be, as Agamben says, and the potential not to be. Potential not to be is unknown. What is known is the fact that one has the potential to be other than what one is. And I think, in some sense, therefore, the future is a known territory. We know the shape of events to come. And we know the movers and the shakers of events everywhere in the globe. So I approach the subject with great humility. I'm not a fortune teller, not a fortune hunter. And all I can do is to speculate what the future might be, and from the vantage point of the present. My second point is a bit more time consuming, but I'll be brief. And it is this. It is a point that was first raised by a jurist called Carl Schmitt in 30s. And Carl Schmitt wrote several books. One of the books was called Constitutional Theology, in which you worship the Constitution as it is, in which you treat the juristic discourse as a species of theological discourse, and juristic events as theological events. I try to show what was wrong with it all. But we stick with this phrase, constitutional theology. I think it's a very important phrase before I come to basic structure properly, because much of the discourse in Keshav Nabhati, the basic case, is theological. Let me give you examples. Example one, Chief Justice Yashwant Chandrachud, who, as you know, dissented, as it were, if there was a ratio of the case, we'll come to this later. But he said Parliament has full powers to amend every aspect of the Constitution. And this power cannot be curtailed by anything. There were 6 judges who said this, and 6 other judges said differently. They said Parliament was subject to some restrictions, even amending power. But what the important moment is what Justice Chandrachud said. He virtually ended his judgment by the invention of a judicial curse. It is then a judgment. It's very long, but you must read it if you are studying law. What does it say? What does he say? And I quote him. He said, we've given the parliament and people who are elected vast powers to do good. And now is the curse. And he says from the high bench as a Chief Justice, would-be Chief Justice of India, he says the following, and I quote, woe betide those in whom the country has put such a massive faith. Now, what is this if this is not law? This is not philosophy. This is a curse. And the first time in history, judicial history, a curse has been uttered by a man who becomes Chief Justice of India. So there's theological flavor you get out of Keshav. We also get the stirring words of Justice Trivedi in the Keshav Nabhati. What does he say? and I quote from memory, he said the Constitution is not meant for men with long purses who quibble about the meaning of words. What is then the Constitution meant for? As Advaiti says, the Constitution is meant for reverence by the people. It's an object of reverence. Again, you find theological flavor in the discourse of amendment. Go further, in the post-emergency period, when many state assemblies were dissolved, the Supreme Court upheld the resolution of this assembly. The case known as Union of India versus Rajasthan. What did Justice Goswami immortally say? He said, the Constitution, and I quote, is the last resort of the bewildered and the oppressed. Similarly, many people have said words that have spiritual power. In Bhagavad Gita, Lord Krishna, you remember that? It's a famous verse. He says essentially that Paritraya sadhunam vinasaya chaduskatam dharma sanstapana hetu sambhavami yuga yuga. I will happen in every so often, in almost every age. Why? I will happen to destroy evil and to re-establish dharma and to protect those who uphold the dharma. This is what I think is from, if you believe in Krishna, if you believe in Punarjanma, if you believe in sanstapana of dharma, if you believe in life after life, this is pure theology. And worth the reverence it is known for. So in a sense, we are all missing something in Keshwarana Bharati. If we read it, but we don't read it, that's my doubt. That's a separate matter. I've met very few people who have read the judgment. It's more than 1,000 pages, and it is very complex discourse. So it is not widely read. It cannot be head noted. It cannot be footnoted. I'm the only person in India, perhaps in the world, who has read the judgment 27 times. And I know it by heart. And I don't like to be apart from you or distinct from you. It's not a matter of praise, it's a matter of shame. All of you must read the judgment fully. Discourse in Keshwarana, I say Keshwarana is the Constitution of India. Whether you like it or don't like it is a matter of personal choice. But not what the government of India prints, but the judgment is the future Constitution of India. It is the next most important document after the Constitution of India. So we cannot proceed in legal or political science education without reading the case. And I very often say that the problem before India is not the illiteracy of the illiterate. That can be managed. The problem before India is the illiteracy of the literate. Those who go to universities and hold degrees, and their illiteracy is the problem. They should be more literate. They should not read a case by mere head notes. They should not be ratio hunters, mere ratio hunters. Summarize the case, digest the people. Legal discourse is meant to be read. And who else will read it if not the law students and law teachers? Therefore, develop the bad habit of reading judgments over and over again till you find the real meaning, legal and social, of meanings of social judgment. I had a friend and a teacher called Julius Stone, and I had the privilege of working with him in Australia. And he used to call me a son, always a son, this and that. And what did Julius do all his life? What is he known for? He is known for one thing. He established over and over and over again that a case does not have the ratio. Even ordinary cases in tort law do not have a specific ratio where the story ends. It has multiple ratios, multiple ratios, if you like. So Keshwananda is a discourse. I did not study with him, but there was another gentleman whom I read very carefully called Carl Llewellyn. And Carl Llewellyn used to say to his first year students in Chicago in law, he said the following. He said, do not look at what the judges say. Do not look at what the judges say, but look at what they do with what they say. And this is very important for reading and understanding a judgment, any judgment, whether insurance, banking, bill of lading, charter party, any judgment, not from Keshwananda. Every judgment has many ratios, depending on the context. So the first thing we have to ask about basic structure is what is the context of basic structure? And the context of basic structure, doctrine, was precisely the context which was carried by the 24th Amendment, which said Parliament of India has power to change every aspect of the Constitution. It is the power, and the Attorney General then argued before the court that Parliament has the power which cannot be restricted. It is unfettered. When judges asked him, what can Parliament do if there are no limits? And he said, Parliament may convert a federal structure into a unitary structure, a republican structure into monarchy, a secular India into a theocratic India, and so on. And everybody was stunned. Such power of complete change is not merely to bring in changes in the Constitution, but changes of the Constitution. And that's the important distinction. Change is in the Constitution is provided by Article 368, following procedure and substance of Article 368, the amending article, you can change the Constitution. But change of Constitution, replacing it, repealing the present Constitution, bring a new one. Does that power lie with anybody? Does it lie with Parliament? Does it lie with the court? Does it lie with the media? Does it lie with army? Does it lie with people at large? This is the question. And this is a question of basic structure. I would think that we would appreciate the context in which the court decided. And after 2 years, we knew, Indians knew what was meant by that argument when the emergency was declared in 75. Keshwananda happened in 73. So I think we should look at the context. The context is one, and I must clarify very clearly, and this is not clarified now. The context is not a political context. What do I mean by political context? A political context, the context of competition for power, of circulation of the governing elites by elections, by some method. This is not the politics that judges are entitled to practice under the Constitution. But the judges are entitled to practice another kind of politics, and that is constitutional politics. Interpretation of constitutional provisions, interpretation of the constitutional spirit, with the underlying animating provision. And I think this is where the idea of basic structure begins to happen. It was later. It was there in Sankari Prasad. It was there in Golaknath. I won't bore you with those details, which are well known. But it terminates fully, although division of opinion in Keshwar Nabal. The essence of judicial power, as distinct from essence of political power, is this. Political power, competition for political power, is always self-interest. But the interest of the leader, interest of the party, these things come first. The essence of judicial power is that it is disinterested in the outcomes. It is able to take a distant perspective as to what the Constitution means. The judges deciding the case one way or the other, by and large, have no interest in the outcome. They are merely interpreting the Constitution according to the oath under the third schedule that they've taken. And therefore, this is a very interesting distinction that we must bear in mind when we care. I will come to my fourth point. The discourse of basic structure and its central features is a discourse which some jurisprudence will call illustrating the open structure of judicial interpretation. Open texture of judicial interpretation. Let me illustrate. Yashwant Chandra Chud dissented, as you know, and gave plenary powers to Parliament in 1973 in Keshwar. In Minerva Mills, a case that followed a few years after the emergency, he said, look, you can't amend everything in the Constitution. I'm a disciplined soldier of the Constitution. I must follow, well, no matter what my views were, I must follow the basic structure. And he said, you certainly cannot place a provision like Article 31C. What is Article 31C? It said all Parliament has unlimited powers to enlarge the ninth schedule and place all the social welfare legislation under Article 31C. Justice Chandra Chud clearly said there, in Minerva Mills, I think, that there is one more essential feature. In addition to Keshwar, what is that essential feature? Justice Chandra Chud said, essential feature is, and I quote, harmony and balance between fundamental rights and directive principles. Where did he get it from? He was interpreting Keshwarananda. So list of essential features is not closed. Essential features can be developed from situation to situation. Whether essential features are violated or not is also a matter of interpretation. And therefore, look at Justice Khanna. What did he do? He held in Keshwarananda what he had. He said you can't amend the Constitution as you will. You have certain limits. Let's say that's what he held. What did he do soon thereafter in Rajnarayan? Oh, he said, forgot to say in Keshwanda that secularism is a basic feature of the Constitution. Mere fact that judge happens to be on the court to put an addendum to his earlier decision is not technically open for a judge to do it. But he did it. This is what I call childlike jurisprudence. Not childish, childlike jurisprudence, the world of difference. And he says, I'm on the bench. I forgot something to say there, 73, let me say it in 75. Again, my point is not to criticize or applaud Justice Khanna, but to say that there's an open structure, open texture of essential features. Court can keep on adding essential features. My fifth point, of course, there's a constitutional discipline. The court ruled clearly in Keshwanda that only the Supreme Court can apply the basic structure and essential features. I would simply say BSEF doctrine, basic structure. Only Supreme Court can apply BSEF. It is not for any other court in India to apply the basic structure doctrine. We all know that this is not how things function anymore. I'll come to that. But they provided discipline. Secondly, it says the basic structure can only apply to constitutional amendments. This was in 73. What happened subsequently? We all know that the court extended it very widely to all constitutional provisions, not just amendment. I asked, how is Bommai possible under Keshwanda Bharti ruling? You know Bommai and what it ruled. It's a very important decision for federalism, but not only for federalism. And I'm very fond of it because Justice Jeevan Reddy cited 6 features of Indian secularism, constitutional secularism I developed. And he said Professor Bakshi has these 6 features. He cited them in this paragraph. And he said, I approve of it. He went one step further and said secularism is a basic feature of the Constitution, according to Keshwanda. That is right or not, I'm not going into that. So the point is, I wanted to make the point is that the point simply is essential features are not closed forever. They are subject to judicial interpretation and they have an open structure. And you can supplement rules of interpretation by this. For example, the old rule of interpretation, statutory interpretation. Look, basic structure was not merely applied to constitutional amendment, but to governor's report and discussion in recommending president's rule in Bombay and president's action in imposing constitutional rule. Now, presidential action, can you call it basic structure? No occurred on the original 1973, just according to Bombay. Why? Because the judges felt that basic structure can be violated in various ways. And a president's decision may also violate basic structure. Executive acts are subject to basic structure, discipline, not just constitutional provisions, constitutional provision of Article 368. What did Chief Justice Chandrachud say in Vinava? The old rule, and you might talk of old rules and new rules, I'm reminded of what happened to me at Nirma University. A couple of years ago, I went to Nirma University to speak on something I don't remember. But my subtitle was Old Wines in New Bottles. As I started speaking, I realized I was in the state of Gujarat. which was a state with prohibition. I was in Gujarat before, and I was a disciplined person. I didn't imbibe any drinks. But I'd forgotten it a long time ago. So when I rose to speak, I realized I might be committing an offense when I talk about old wines and new bottles with the prohibition thing. So I immediately said, I must change the metaphor, not violate the Gujarat law. And I said we must speak of old dal in new cookers. This what Gujaratis do. You put old dal in new cooker. So put old dal in new cooker. What is new cooker that Chandrachud discovered? He said very importantly in Minerva Mills that Article 14, 19 and 21 constitute a golden triangle. And Parliament of India cannot by legislation or amend, alter the balance between fundamental rights guaranteed by this golden triangle and dietary principles. In this respect, dietary principles must remain subordinate to fundamental rights. The harmony he spoke about earlier, we spoke about earlier. He quoted Gurudev Tagore. You know, his famous poem where he says, "Oh Lord, take me to the heaven of freedom." Big, nice poem. Heaven of freedom, which is what the Constitution promises. What Chief Justice Chandrachud added was, yes, heaven of freedom, yes, but not, and I quote him, not the abyss of unrestrained power. Not the abyss of unrestrained power. And judges are there to check unrestrained legislative power under Article 32 of the Constitution. Power that violates rights. That's the sole reason why you have courts and Supreme Court, ultimately, to avoid the experience of abyss. Whether or not you reach the heaven is another question. But there is a hope. The hope thrives only because people make an effort to avoid the abyss. And basic structure is one such effort, major effort. My sixth point, I must now end. Several phases of basic structure, essential features. You know it all. One is the invention of SOL, social action litigation, which many Americans in India call public interest litigation. There is a big difference between the two, but I won't speak to it. I've written. If you look at social action litigation, it is possible only because of the doctrine of basic structure and essential features. I won't say anymore. Whole history of social action litigation, not public interest litigation, social action litigation, is a history of developing further the ideas, the values, the goals of basic structures and features. The invention of new jurisdiction, for example, the curative jurisdiction, when the Supreme Court itself is able to say that we might have done something wrong, or the power to do complete justice in Article 42. These are offspring, as it were, of basic structure. The next phase is the phase of, what shall I call it, feminization of basic structure. Recently I gave a Sunanda Bandari lecture in which I talked about Vishaka. Nothing in the Constitution said anything, even remotely, about sexual harassment in workplaces. Nothing. Not even the directive principle. And yet, on the eve of 50th Independence Day, Justice Verma and others ruled that sexual harassment is unconstitutional in workplace and laid down the law till Parliament acts otherwise. And when did Parliament act? 13 years later. Till then, the Supreme Court law held. I would not go further on this, but feminization of basic structure is a very great advance. You can see recently a decision by Justice Dhananjay Chandrachud. And again, if you read them carefully, two decisions of women officers in the army, they derive directly from the basic structure. So it's no longer a constitutional amendment. It's no longer a union executive act. But it is the conduct of ordinary people outside the constitution in the private sphere. This is now regulated by norms of basic structure. That's the point I should make. Genderization of basic structure is another phase. By genderization, I mean the whole movement from Nas to Naute Johar. What was that movement for? The whole movement for trans people. What was it for? Again, it was taken out of the Golden Triangle, 14, 19, 21. Take Coelho. Now coming to my end. Coelho against is a decision on basic structure, momentous decision. He said, so far we had given Parliament the power to add number of statutes which violate manifestly expressly fundamental rights, but they are put in 9th statute. And they are therefore protected, they can't be reviewed. My friend Justice Siddhartha used to say, and I said in judgment, he said, ours is the only constitution that needs protection against itself. What's the meaning of putting a statute, list of statutes, some 200 odd statutes, even if they violate fundamental rights, 14, 19, 31, into 9th schedule, that courts will not look into it. In Coelho, they said, henceforth, we will examine each statute and decide whether Parliament has power or not to incorporate the statute in 9th schedule. Whether it has statute with anything to do with social justice or not. This is a justiciable matter. I think quite important extension of basic structure. You all know about Sabarimala. And you now know about the review of Sabarimala that is currently ongoing. I won't speak into it. So let me quickly conclude. And I want to conclude on an important point, I think. Even if you're tired, pay some attention. The point is, what is the distinction, if any, between basic structure and essential features? Is there any distinction? Should we make a distinction? Well, I do. And I do it by reference to a alliance called striptease. And I call Kekrana Bharti decision a constitutional striptease. When you shed every garment, when it comes to shedding the last garment, you are shy and you refuse to shed it. What did the Supreme Court refuse to shed? What was the last garment there? That's the basic structure. That is the power of the court to perform judicial review. We won't part with it. We won't part with the power of interpretation. Parliament will give all the plenary powers to amend the constitution, but not the power to oust the jurisdiction interpretative task of the judges themselves. And therefore, the basic structure essentially can never be changed. Please remember that. Essential features may vary. Very often I'm asked, I'm now advancing in age, so people ask me how is my health, particularly COVID times, but even otherwise. I used to say I can only use the language of the Supreme Court. My basic structure is sound, but all of my essential features are topsy-turvy. The question arises, how can there be something called a basic structure if all the essential features are taken away? Can you read Justice Chalameshwar's dissent in the Haryana case of Rajbala, where 60,00,000 women were disqualified as stroke of pen by a legislation which said if you did have such a toilet in your house, then you can't contest. And the majority said this was violating the basic structure. I said the Justice Chalameshwar said such disqualification are perfectly rational. He did not disagree with basic structure, but he somehow left it compromised, as it were. So, basic structure is a trope or a root or a metaphor through which essential features are discovered, are determined from time to time, and disrobed or dismembered. There's a difference between constitutional amendment and constitutional dismemberment. Dismemberment of constitution are two different things. And therefore, I conclude now with reference to what is called a jontology. What is a jontology? It is said to be a new word. Agnotology is a new word, not agent, agnotology, which says, let us study the doubts that have been raised by prejudices that have been raised by ignorance. Let us study ignorance, not knowledge. My question, I conclude, is the following. Is constitutional theology a better option, a better bet, if you have to choose? Is it a better option than constitutional agnotology, ignorance? Let me end with this. Thank you.
Thank you so much, sir. It's our honor to hear from you. Respected sir, I, Ekta Gehlawat, would humbly request your kind self, if you permit, we would like to pose a couple of questions to you, sir. Can we, sir?
Can't hear you.
Ekta, carry on.
Manika, can't hear you.
Respected sir, whether we are audible to you?
Now you can, I can hear you.
All right,
Yes.
sir. Ekta, please go ahead with the question.
Yes, sir. Whether the basic structure doctrine has any concurrence with legisprudence, demosprudence, and jurisprudence.
Whether it has any relation. Yeah?
Yes, sir.
Yeah, okay.
Yes, sir. Yes, sir.
Yeah, okay. Well, I think quickly, very quickly, demonstrance is a word I have been attacked of being a cheerleader of. I'm called a cheerleader, not by name, but implicitly. People call, and reference is clear, to the cheerleader of demonstrance. Reference to me. I'm not a cheerleader. I'm just describing the social fact that we in India live under three prudences. One we think we know, but we don't. It's jurisprudence, the first principles of law. But there are two other prudences. Legisprudence, we don't know anything about. Legisprudence is the wisdom of legislature. And although the court always starts, Supreme Court starts in a challenge to the validity of the act with the presumption of validity of a rule. It always says, you show me why it is unreasonable, why it is arbitrary. I will presume otherwise until you prove it to me. So legisprudence is a very high demanding area, but we are crazy after case method and so on. So we tell our students only to read cases. Very few people read the law, which is bulk of the law is made by legislature. We don't know, unless the matter goes to court. We don't know what the statute says, how the statute is made, etc. And demosprudence is the prudence of the demos, the wisdom of people, or attributed to people. Now, people, of course, vary. Women are people, children are people, scheduled castes are people. So there are all kinds of sums to be made. But clearly, decision on gender justice, feminization of basic structure, genderization of basic structure, are people's jurisprudence coming into court, and court saying, yes, there is no longer a tussle between parliament and court. The tussle between, it's a within demonstrance as to who shall count, whose voices shall count as people's voices. I think one can, it's a very interesting question. There's a lot of work to be done. But it is important to say that basic structure is unrelated to these three prudences: jurisprudence, legisprudence, and demosprudence. And secondly, it is strong enough to say there is something called overreach. Judiciary is doing things which it should not do. This is complete nonsense, because judiciary is doing nothing but interpret the constitution, which is their duty to interpret under the third statute, oath. And that they have a duty to do constitutional disinterested politics, what is good for the nation. Yeah. And what is the second question?
Yes, sir. The next question is, what the basic structure doctrine has any idea of universalism in global world?
Oh, by the global world, the basic structure doctrine has traveled all throughout South Asia, Bangladesh, Nepal, Sri Lanka, all the SAARC countries, almost all the SAARC countries, I don't know about Bhutan, but most of the SAARC countries have adopted various and developed various ideas about basic structure. So it is always the case that it has spread. It has spread into Malawi, it has spread to Africa, it has spread into Latin America. The idea of basic structure or of constitutional identity, the constitution of the personality, has spread variously. And one of my favorite judgments, I wish I had a quotation here, a very good quotation, was by the Chief Justice of Tanzania High Court, who said the courts must, and the court declared the election of a president as invalid constitutionally. and gave the Election Commission 50 days to hold a re-election. And there's a beautiful passage in paragraph 399 of the judgment, which says that let the message go forth. My words, not the judge's words, are more powerful, infinitely more powerful. I'll send it to the dean and I can replicate this to all audience. I just saw small paragraph, I quote the whole paragraph there. And the dean would kindly circulate it among the webinarists. He said the message should be spread to the hills, to the forests, to the congregations, to church, to everywhere, to streets, that the Constitution is the supreme law. Now, what is this effect of basic structure? So it is spread far and wide, but it has been adopted. The 8th Amendment decision in Bangladesh is Bangladesh's decision. It adopts the idea of basic structure, secularism and all that. But it adopts it in Bangladeshi way. So each country, many countries have adopted the doctrine, many countries have reshaped it, many countries have gone beyond it. And again, we don't study it, unfortunately. But it's to use the modern language, contemporary language, it is a prize export commodity of India, the basic structure doctrine.
Thank you so much, sir. Sir, the next question is the basic structure tangible or subject to the interpretation by courts? What is the effect of this doctrine on the courts and the executive? How does it affect the common man?
It depends on who the common man is, in your opinion. If the expression common man is constitutionally offensive, although I used the quotation marks. All citizens are citizens with equal rights, equal dignity. I know higher or lower citizen. I know uncommon citizen, uncommon citizen. We are all common citizens, including the judges, including members of parliament, including any executive bureaucracy, including army. We are common people. Common is, to be common is an art, horizontal, to be common with everybody, to lie with everybody, to be everybody, companion to everybody. So I'm going somewhere else, but your question is important. What's the impact of basic structure? The impact is found in the robust conception of freedom of speech, freedom of religion, right to being a plural and diverse society, and you find it everywhere in the world. Free of racism, free of gender discrimination. This is the constitutional morality of basic structure. And in fact, right from the words of preamble in 1949, the constitutional morality is found there. So, in a sense, while questions should be empirically studied, it is clear to me that people of India, in a general sense, do not want any part of the state to be sovereign. Only people of India are sovereign. And the Supreme Court in 1955 or something, in Burakkar Cole versus Union of India, made a very important distinction. He said that people of India are non-legal sovereigns. It drew a distinction between legal and political sovereignty. And it appears in Kekranda also, in Justice Beg's opinion. Justice Beg also takes that line, that people of India are political sovereigns, but Parliament and Supreme Court, etc., whatever you call it, are legal sovereigns. The distinction between legal and political sovereignty is very important. And legal sovereigns are not necessarily political sovereigns. Political sovereign can hold accountable, can put into question this legal sovereignty, even of Parliament. It's not treason, it's free speech to say this. So, and it's our duty, and the fundamental duties by 51A, small paragraph in the Constitution, which people gloss over, don't read. But those 11 duties are very fundamental to all citizens. All, it applies to everybody, including judges of the Supreme Court, including the members of Parliament, including you and me. It applies to as long as we are citizens, right? Common Indian. And one of the duties is to develop scientific temper, spirit of critical inquiry, I'm quoting, and reform, and excellence in all walks of life, individual and collective. This is a duty, not a right. Every citizen has to perform this duty. And therefore, there is a movement to coalesce the two, legal and political sovereignty. And we have to read the active principles, the fundamental duties of citizens in a proper way. Why are they inserted in the Constitution 1976? Why are they not repealed by further constitutional amendment? And so on. Now, as to what is the impact of government, I think, let me know, sorry, but I think theoretically, basically, it's a very interesting area that it is not just a juristic doctrine, but a social doctrine. And every power is subject to limitations. That is basic system. There is no sovereign power. There is only distribution of superior power. What is superior power? A superior power is the power to act within limits of conferment, jurisdiction. Parliament is supreme in its own sphere. Legislatures of state are supreme in their own spheres. It's entries, list 1, list 2, list 3, and 7 schedule, and so on. Constitution recognizes supreme powers in the appointed jurisdiction. It does not recognize that sovereignty lies with any of them, or all of them put together. The political sovereigns are the people. That's a distinction that is made.
Thank you so much, sir. The next question is, if constitutional morality is treated as basic structure, can there not be better social justice rendered to the ailing migrant laborers?
Migrant labor?
Yes, sir.
Well, I think there is a double multi-pronged question. Thank you again. First, I must clarify that in my book, Constitutional Morality, which I call CM for short, CM is ingrained in the Constitution itself. It is not a recent addition by judges. It is there in the Constitution, provision and preamble from the word go, from the beginning. So that's very important to bear in mind. Certain examples of application of constitutional morality may be problematic, but it does not mean that they are not examples of constitutional morality. When I say problematic, I mean can be questioned. Like Justice Indhu Malhotra questioned in Sabrimala whether a PIL, so-called, can lie when denominational rights are asserted. She did not disagree with or CM per se. She only said there is a question, and now question is before the Supreme Court in extended petition. So there might be differences about the application of CM in certain cases, and this dispute should be resolved. I don't believe they should be resolved omnibussly and forever. There is no way in which law can be settled forever. Law is always on the move. New situations will arise, new contexts will arise, and new interpretations will arise. The latest decision of women's inheritance in Hindu law, practiced last week, the case is the point. So the point I'm making is constitutional morality is not a new thing. It informs the Constitution from the beginning. It has informed also the interpretation of Keshwara Bharati and its progeny, normative progeny that I've just discussed. So that I don't think is a problem. Certain people have expressed strong views, like Attorney General Venugopal, when I said it's a dangerous doctrine, it should go. In such a website, Lalita debate lecture. And basic structure should also go. He thinks it's gone too far. But they're inseparable, constitutional morality and basic structure. That doesn't mean judges can do anything they like. Well, you must realize that judges work very hard to write a judgment which endures, which you can pick up any time and tear it to pieces. Judges can't reply back. Judges have a duty to reason. This is not the case in any other walk of life. You don't have to write a judgment, giving reasons, argument, to and fro. So judicial process is a special technique of arriving at a result, right or wrong, we disagree. Merely having opinions is not good enough. From study this. All right. As to migrant workers, yes, there is UN Convention on migrant workers, which we are subscribing, which we have subscribed to. There are also a number of provisions, directive principles. We must relate to migrant workers. There is a migrant workers law also, passed by Parliament. So one has to examine in what is the focus of the question about migrant labor. The existence and the dignity of labor is secured by the Constitution. Part 2, Part 3, Part 4, and Part 4A. This is the new golden triangle, the Bakshi golden triangle, not 14, 19, 21. The Bakshi golden triangle is Part 3, Part 4, and Part 4A of the Constitution. They have to be reconciled. So it is there that you find your particular problem. I don't get it now, but there's a particular problem about migrant labor. That the golden triangle should go to. But I'm aware that I'm not answering the second half of the question very clearly because I don't know what the thrust of the question is.
Thank you so much, sir, for answering the queries of the participant patiently. Now I would like to invite Dr. Avnish Bhatt.
Respected sir, we are really mesmerized and overwhelmed to hear you. It was really mesmerizing, and we could have heard you continuously, but it's a very long already you have taken. So I humbly request our academic coordinator Monica Khorola ma'am for the vote of thanks.
Thank you indeed.
Thank you, Avnish. Sir, it's been wonderful listening to a great teacher like you. And we have our participants have wonderfully been taken through Keshwan and Bharti basic structure and how you judges have made this lecture immensely beneficial for the students and all the people in the academic field. And we understand that to have a stronger society, the constitution must hold, and to hold good, the basic structure must continue to follow. So we thank you on behalf of ICFI University, Dehradun, for taking up your precious time. It's been an honor to have you here, and we look forward to you, to your good health, and wish and pray that sometimes you visit us at our campus. Thank you, sir, on behalf of ICFI University, Dehradun.
Thank you very much, all of you.
Thank you very much, sir, from my side also. Thank you very much, sir.
Thank
With
you.
folded hands, sir, you have taken so much of, you have spent so much of valuable time of yours. You are very kind, it's very kind of you. Sir, with your permission, may I close? May I close, sir? With your permission, may I close the meeting?
Anytime you want to, every time.
Okay, sir. Okay,
Thank
sir.
you.
Okay. Thank you. Thank you, sir. Thank you.
Bye-bye.
Thank you, sir.